Welcome to you all, wherever in the world. I know there's someone from Australia and someone from Argentina. Bonjour à tous et à toutes. Despite the physical impossibility of being together, webinars like this give us an opportunity to examine the problems presented by Brexit for the United Kingdom and its neighbours and its former EU partners. And as on previous occasions at these webinars, I repeat, it's not our purpose to rerun the referendum. It's not our purpose to lament past political choices. But regardless of how we voted, or if we didn't vote like me, couldn't vote like me, a Brexit, whether with an agreement or without an agreement, presents very many important uncertainties which have to be addressed. Lawyers in practice, clients, officials, courts, political leaders have got to confront these questions. Now, today's specific topic is the impact of Brexit under various scenarios on the island of Ireland. And I recognise with particular appreciation the efforts in arranging the speakers today and the topics, the efforts of Fionnuala Connolly of the Bar of Northern Ireland, also a former habitué of my court in Luxembourg. I thank her for her help in putting the programme together. She has had the immense pleasure and honour of having as a family friend that great activist, political spokesman, statesman, the late John Hume, winner of the Nobel Peace Prize. And on our website, I invite you to study his speech on the receipt of that great prize, and Fionnuala's personal comments about our family's connections with him. Now, peace is a nice word. Peace is opposed by no one, endorsed by everyone. Peace is great. And yet, strangely, repeatedly, we're being warned that Brexit presents a threat, a danger to peace in Ireland. These are deeply dangerous matters. And we have four exceptionally expert speakers on different aspects of that problem today. First, we've got the man whose surname is, in my humble opinion, the most difficult to spell of any holder of judicial office in the European courts. It's Colm McCloskey, spell that one, and he was, for a while, the only High Court judge in Ireland competent to try a case in Irish, in the Irish language. He arrived a little while ago in the General Court as another judge, like myself, from the common law tradition. And at the moment, he's studying the role of Irish judges in our courts and the use of the Irish language. But like each of our speakers, he has vivid memories of violence. And our second speaker is Professor Katy Hayward. She's not a lawyer. She's a professor of political sociology at Queen's Belfast. And she's been working on questions of the links, the impact on Ireland and Irish people, north and south of the border, the impact of EU membership. And now she's working pretty much full time on Brexit. And she's been deeply involved in the really difficult questions of peace and security in the province and in the Republic. She's, I would say, painfully expert in this field. Our third speaker is Professor Brice Dickson, an old friend of our society, a former director, and his topic is going to be the impact of Brexit on employment and discrimination in Northern Ireland. topics which history endows with profound importance. And these questions are deeply relevant to life on both sides of the border. And then another old friend, and a francophone one, is a member of the Court of Appeal in Northern Ireland. Formerly, he was the senior judge for judicial review in the province, now in the Court of Appeal, Lord Justice Bernard McCloskey. So I think this is the first time in our history that we've got judges from the General Court and the Northern Irish courts together on a single programme. And he's got a strong interest in questions of the rule of law and fundamental rights. Obviously, both judges are speaking personally, informally, in a completely personal capacity. Then, as they speak, you can use the Q&A function, which is now visible at the top, probably slightly to the right of center of your screens. You can use the Q&A functions to raise whatever points you wish, and there will be questions after the speakers, after the four have spoken, and then we'll have a summation by my old mentor, Sir David Edward. I think that's all we need to say by way of introduction. So it's my pleasure to ask my former colleague, Colm McCloskey, to start the discussion. Colm, you're welcome.
Thank you very much indeed. Bwalem tosu la couple of focal scoilga a raw ta an avor or an behan shaliv new couple of mio hin couple of blino hin honig mishka parsanta focal had Brexit in Eochaidh as in focal shin no sasamach shabadir sasna amach on Europe. Those are a few words in Irish, just as we were preparing the introductory words privately. It was revealed to me that no one had ever spoken Irish at one of these webinars before, so that's now done and dusted. J'entends qu'il y en a parmi les participants ce matin quelques français ou des francophones. Je veux tout simplement dire que je suis ravi d'être avec vous ce matin. C'est pas la première fois que j'ai rencontré votre association, parce qu'il y a presque 30 ans maintenant, j'ai commencé mon premier emploi à Londres au sein de la Law Society, où mon emploi c'était de promouvoir le marché unique, tout ce qui est la réalisation du marché unique. Mon chef était un homme à négocier, Thomas Adamson. Mais il paraît que je n'ai pas très bien fait mon travail, sachant toute l'histoire de Brexit qui est venue entre-temps. It's a great pleasure to be with you this morning. A greeting from Luxembourg. I'm happy to try to share an Irish perspective on Brexit. As I was just saying there in French, I started my legal career employed by the Law Society of England and Wales in London, where my job was to engage with, explain and promote the achievement of the single market. Halcyon days, but as I was saying, it doesn't appear that I did a very good job, bearing in mind what's happened since. Ireland and the United Kingdom, as it's tried to say, have had difficult relations for centuries, particularly difficult relations, I think, up to the achievement of independence and for 50 years thereafter. But everything changed when the United Kingdom and Ireland jointly entered the European communities on the 1st of January 1973. And since then, no one could gainsay the proposition that relations improved very considerably. And that is partly because Ireland did not feel under the shadow of or compelled to act always as Britain acted. In other words, Ireland's joining of the European communities allowed Ireland to fill its lungs with its sovereignty, if I could use that. Ireland, by sharing its sovereignty, gained sovereignty. Britain, as we now know, had a different experience of sharing sovereignty, for better or for worse. But Irish relations, London-Dublin relations, were reset when we both joined, and British-Irish relations continued to improve as we saw how much we had in common as two English-speaking Atlantic island states, imbued with the common law traditions and with a shared view, a shared worldview in many ways. And very often we had each other's backs with respect to all kinds of questions in the European community and subsequently in the European Union. Therefore, it goes without saying that the loss of the United Kingdom from the Union is a particular blow to Irish interests. I see that almost every day in my work here in the General Court. We are the last man standing for the common law, and although common law represents at least half the world's population and a huge percentage of the world's advanced trade, it is little represented in the Union. It is in the context of improved relations between the UK and Ireland that the border, the politics of the border came to be assessed, analysed, and eventually improved. It bears remembering that during the Troubles, the common travel area, in other words, a mini European Union, a nascent version of the European Union, continued to exist with the four freedoms that are enjoyed in the Union being enjoyed between the United Kingdom and Ireland years before we ever joined the Union. There was, of course, border infrastructure for many years, but that border infrastructure attracted appalling acts of violence, which on every occasion shook the very spirit of the Republic of Ireland and the North of Ireland, and of course the rest of Great Britain. There is too much competition for which atrocity might have been the greatest during the appalling years of terrorism and violence on the island of Ireland, and in particular in Northern Ireland. But for me as a young man, the murder of Patty Gillespie, who was forced to drive a van loaded with explosives and remotely detonated at a border checkpost, murdering British soldiers, and of course himself, stands out. It is events like that which explain why the Irish government have had as its principal foreign policy objective since the adoption of the Good Friday Agreement to maintain a position whereby there would be an invisible border. That has been an objective which the government have quite rightly sought to advance. There's also an objective which the government of the United Kingdom have sought to advance, and of course the European Union. The policy objective was first advanced by Theresa May in her first version of the withdrawal agreement. And we remember the tumultuous votes in the House of Commons as it was objected to, because the backstop, remember that old friend, the backstop was not acceptable to various factions within her own party and to other persons in the House of Commons. Eventually replaced by the Northern Ireland Protocol, which I think is a real triumph and misunderstood in some quarters. Its central achievement is that it will ensure, if implemented, that there will be no infrastructure on the border. Tony Blair has confirmed that the a central tenet of the Belfast Agreement was, a central objective, sorry, was to ensure that there would be comprehensive removal of all infrastructure at the border. Without that, there couldn't have been a Belfast Agreement. And it is absolutely essential that that be maintained. No gamble should ever be taken with that issue. And it's very clear at this stage, with the new administration about to take office in America, that no trade deal will happen between the United Kingdom and the USA if any part of its withdrawal agreement, any part of the terms upon which it leaves the European Union imperils the absence of border infrastructure on the island of Ireland, or imperils any implementation of the Good Friday Agreement. The Good Friday Agreement, I should say, when you read through it and examine how it was arrived at, it came to be because the United Kingdom and Ireland were both members of the European Union. That greatly facilitated the agreement, which has achieved peace for many years now on the island of Ireland. People are right to be concerned that the withdrawal of Britain from the Union might somehow imperil the Good Friday Agreement. The Ireland and Northern Ireland Protocol, I should call it, attempts to ensure that there will be no unraveling and that there can be no going back on the commitments given by all of the parties and the two governments, Ireland and the United Kingdom, in the context of the Good Friday Agreement. Can I talk perhaps a little bit about some provisions of the Ireland and Northern Ireland Protocol, and say this? One of the slogans of the Brexit campaign, and I promise not to reopen that, was the very clever "take back control." Those who believe that is happening have not read the Ireland and Northern Ireland Protocol, because a first general remark I will make about the protocol is that for as long as Ireland remains a member of the European Union, the Court of Justice of the European Union will have jurisdiction in the United Kingdom, and EU law will be applied in the United Kingdom. There has not been, because of this protocol, a take back of control. Quite the contrary. Control will be exercised by institutions in which the United Kingdom will have no participation. That is a juridical fact, if I can use that phrase. And it is an inevitable part of the withdrawal agreement. The second thing I would say about the content of the protocol is that I wonder whether in the corridors of the institutions in Brussels, whether secretly the Bar Council of Northern Ireland and the Law Society of Northern Ireland had lobbyists and spies, because there's one certain other result of the text of the Ireland and Northern Ireland Protocol, is that it is a masterpiece of mishmash. So much of it is difficult to understand and unclear. There will be work in it for lawyers for generations to come. So the lack of clarity and the loose phrases, which are a masterpiece of diplomatic achievement, should surely represent a boon for lawyers as they seek to navigate through some of its very complicated phrases. The jurisdiction of the court arises in two ways, obviously. As everybody knows, the protocol lists the laws which will apply in Northern Ireland, customs union laws and single market laws. And when questions arise as to what they mean, those questions may be referred to the court in Luxembourg by any court in the United Kingdom, of course, including courts in Northern Ireland, and of course by courts in the Republic of Ireland. These questions, as night follows day, will arise, and questions will be referred to the court in Luxembourg. The other avenue of access to Luxembourg, which mustn't be forgotten, is that questions will arise on the meaning of this protocol. Questions will arise as to how it has to be applied, and those questions will be sent to the joint committee. The joint committee which oversees the implementation of the withdrawal agreement as a whole, one of whose specialist subcommittees is devoted to the question of the meaning and application of the Ireland and Northern Ireland Protocol. The joint committee, as I'm sure you know, when it can't agree, will have access to an arbitration panel. And that arbitration panel, it should not be forgotten, is bound to refer questions on the meaning of EU law to the court in Luxembourg. They are not entitled to pronounce upon, if I've understood Article 174 of correctly, they're not allowed to pronounce upon the meaning of EU law. That competence remains exclusively vested in the Court of Justice of the European Union. And indeed, parties to an arbitration dispute can request references as they can under the general application of Article 267. There is one other part of the protocol which I really only fully comprehended, or perhaps didn't comprehend, when reading through the protocol over the weekend, and that is the parts of the agreement of EU law which is left out. I mean, as you know, there is partial application of single market rules and of customs union rules, but there's been an ongoing debate in the Republic of Ireland about possible divergences between the economy in the north of Ireland and the economy in the south of Ireland as a result of Brexit, bearing in mind that it is, as I understand it, a joint policy objective of the government in London, the government in Belfast and the government in Dublin to move towards and to try to achieve a form of ever closer union economically between the Northern Ireland and the Republic of Ireland, and that there should be a move towards the realization of an all-Ireland economy without in any way imperiling Northern Ireland's position as an integral part of the United Kingdom. It is thought that it is possible to integrate the economies north and south for the benefit of all of the peoples north and south, while maintaining Northern Ireland subject to the principle of consent in the United Kingdom. That being so, what's to be said about all of the laws which are not being taken over and applied in Northern Ireland? For example, the Environmental Impact Assessment Directive, or the Habitats Directive, or the Birds Directive, all of the water quality directives, the whole slew of environmental legislation, which is vast. Will it now be the case that Northern Ireland will attempt to somehow disapply those rules and gain a competitive advantage? Will it be cheaper to build a power plant in Northern Ireland because it won't have to comply with the Birds Directive, the Habitats Directive, or the Environmental Impact Assessment Directive? Will the governments of London and Stormont try to gain a competitive advantage for Northern Ireland by deliberately not applying or now disapplying some of those rules? Technically speaking, that could happen, but there is a very interesting provision in the protocol which I think will give rise to significant debate and probably litigation, which is Article 11, which talks about consistent with the arrangements set out in certain articles, the protocol shall be implemented and applied so as to maintain the necessary conditions for continued North-South cooperation, including in the areas of environment, health, agriculture, transport, education, and tourism, as well as in the areas of energy, telecommunications, broadcasting, inland fisheries, justice and security, higher education, and sport. And in view of that aspiration, Article 11.2 says that the Joint Committee shall keep under constant review the extent to which the implementation and application of this protocol maintains the necessary conditions for North-South cooperation. Now, I view that as a competence being conferred on the Joint Committee to review constantly any possible divergences between the North and the South by virtue of the non-membership of Northern Ireland of the European Union and the non-applicability of a whole range of legislation, such as the environmental standards that I have mentioned. In my view, this article is one which permits, where it is perceived that the non-application of certain provisions of the EU law will lead to difficulties, that the Joint Committee can address that, and where there's where the Joint Committee fails to act, an arbitration can ensue. But the exact meaning of that remains to be seen. I think, Ian, I've possibly said enough. I may even have gone on a bit too long, and if so, I apologize. But thank you very much for listening to my musing about this fascinating topic.
This was the first trilingual intervention that we have had in these webinars, and you speak with experience and authority. Thank you very, very much. I'm really appreciative. And now it's Katy Hayward. Please unmute yourself. There you go. Good morning.
Good morning. Hello, everybody. It's a great honor to be with you today. And I was delighted to meet many of you last year when we welcomed the Franco-British Lawyers Society to Belfast. I'm just sorry it's not in person. And I'd also like to thank Fionnuala Connolly for her work in behind the scenes and organising this panel. So I'm going to talk about Northern Ireland in particular and UK-Irish perspectives. And my principal point is that Northern Ireland is both British and Irish. And I'm going to talk about this in relation to the protocol. And I'm going to say some words about Article 11, which I'm delighted has already been mentioned. And I'm going to try and give this some substance and grounding by talking about something quite technical, but something that I think reflects the fact that we're at a really constitutionally, as well as legally and political, at a point of major adjustment. And I'm going to refer to the mapping exercises that took place in 2017 in response to Brexit. So there are two that relate to Northern Ireland that attempted to sort of reflect the fact that the EU membership had enabled devolution in many ways, and it also in many ways also enabled the Good Friday Belfast Agreement and what that meant in practical terms, including in North-South cooperation. So in 2017, we had mapping exercises that looked at what was going to be under threat and challenged by leaving the EU. And the first one that I'm going to think about is the one that happened within the United Kingdom. So the mapping exercise to look at the areas of EU law that intersected with devolved competence. Sometimes it's mixed to shared competence, devolved and reserved. But anyway, they identified in this mapping exercise that took place 154 areas. This number's gone up and down, but generally 154 areas of EU law that intersected with devolved competence. Because devolution is asymmetrical within the UK, because we have a really unique system, a different range of powers is relevant to Scotland, Wales, and Northern Ireland. So in that mapping exercise, which is essentially trying to say what is challenged by Brexit and what is under threat or at risk of Brexit within the UK, what we need to address. They identified 115 policy areas that they said need no further action, because already we have a situation in which things are working pretty smoothly. No divergence was expected or anticipated between the devolved regions and nations and the UK government, or already they had things that were working sufficiently, such as memorandums of understanding. Although they'll keep this under review, the idea is that there'll be no further action needed. In 22 policy areas, they identified the need for some common way of understanding or working together that doesn't necessarily need legislation. This could come through an MOU, it could come through a series of ministerial letters, for example. Sometimes, in some cases, consistent fixes to EU retained law, such as through a statutory instrument, would be needed. But anyway, the idea was that these 22 areas didn't need legislation in and of themselves. This would be, for example, in relation to radioactive substances or blood quality, for example, in procedures around that. And then they identified 18 policy areas where new primary legislation could be required, in whole or in part, to implement common rules and ways of working across the United Kingdom, and potentially a consistent approach to retained EU law. And as you might expect, many of this relates to areas of agriculture and food. And then there were 4 areas of reserved competence that were seen as overlapping with EU law, state aid, unsurprisingly, being one of them, and also, for example, security relating to Eurodac, the database there. Now, as we would probably have expected, Northern Ireland is affected more than any other part of the United Kingdom. This is partly as a consequence of the Belfast Good Friday Agreement and the North-South dimensions. So we have, at the moment, the development of 40 new common frameworks, as they're called, to try and ensure a common way of working across the UK and avoid damaging divergence or conflict within the UK after Brexit. And there's been a push to make sure that these are more or less in place. I say that because the Cabinet Office would like them all to be in place by the end of this year. Slightly more realistic heads are predicting they will not be, but maybe provisionally they will be so by the end of this year, that we know the common framework for working across the United Kingdom. And I think the interesting point with the common frameworks is that they reflect the importance of the EU context for developing devolution within the United Kingdom itself. And fundamental to all of this is the active use of the principle of subsidiarity. The principle of not acting unless it's necessary to have action or legislation in a particular area. And indeed recognizing the value of policy divergence across the territories of the United Kingdom. So there are certain principles that underlie the common frameworks that even allow for more devolved competence if it's necessary. There's also principles relating to joint working, respecting devolved competence. And the understanding behind this is to ensure that the UK as a whole can uphold its international obligations, can engage in trade negotiations with other countries beyond the EU, ensure its security, etc. But that all of this can go on in such a way that they would be confident that there would be no damaging effects for the integrity, if you like, of the United Kingdom. Core to all of this early on was a recognition of the functioning of the United Kingdom's internal market, and the fact that cross-cut a lot of the issues identified in these various common frameworks. But anyway, the common frameworks were seen as fundamental to avoiding dangerous divergence within that, sort of damaging divergence within that. There was also the principle of respecting democratic accountability as it's operated through devolution, and also explicit recognition of the Belfast Good Friday Agreement and the importance of Northern Ireland's unique place vis-a-vis Ireland. The common frameworks don't get much publicity. It's very technical stuff, We've only seen one draft of a common framework so far. There has been stakeholder engagement, but essentially this isn't about setting minimum standards. It's really about a way of governing, a way of operating within the United Kingdom. As you can see, it's a very different approach to the United Kingdom's internal market bill that's generated a lot of controversy over the past few weeks. Fundamentally, it's a very nuanced approach. It's intended to allow for flexibility and divergence within the United Kingdom rather than imposing a top-down principle that doesn't recognise or doesn't allow for asymmetry within the United Kingdom. And it can only go as fast as the slowest member, if you like, because it's a joint operation. They all very much depend on the progress that's being made in the various parts of the UK. Now, as you would expect, the common frameworks overlap considerably with the protocol. And one thing that's very notable, so the protocol in Ireland, Northern Ireland, one thing that's very notable is that hasn't explicitly been recognised in any of the documentation that's been issued by the UK government on the progress made in the common frameworks. We have an update every quarter on that. And if you look at what the range of areas that the protocol covers, this has already been touched on from arising from Article 7 of the protocol, we see that many of those policy areas identified across all aspects of EU law that were seen as relevant to devolved competence are directly affected by the protocol or relevant to the protocol. This includes those areas that where it was considered that there would be no further action necessary, such as PPE, for example, which is obviously an important topic in tobacco advertising. At the moment, they're not wanting to move on this. They've got enough on their plates, but that's worth noting, I think. Also, we see those policy areas where non-legislative approach is required or a legislative approach is required, directly affected by the protocol. And these are really important areas. And the reason I'm mentioning it is because what we have in this is a situation where Northern Ireland will be obviously tied into following the principles of the values of the single market and the rules of the single market in particular areas. And interestingly enough, of course, it's dynamic alignment. So if the EU regulations in those areas are amended or indeed replaced, that automatically applies in Northern Ireland. So if we have divergence within the UK, as we might expect, we see there will be pressure being placed on those common frameworks. This is partly why we have the rationale behind whatever rationale it was, but some of the incentive behind the UK internal market bill, which we may discuss later if you're interested. Another aspect, of course, I mentioned state aid as a reserved competence, directly affected by the protocol. Northern Ireland following the EU state aid rules as it relates to the protocol. Again, you see potential here for tension and divergence. I mentioned 2 mapping exercises. The second mapping exercise that took place in 2017 was conducted by the EU and the UK with considerable input from Ireland. And this was on North-South cooperation as it has been enabled by EU membership. North-South cooperation, of course, being an integral part of the Good Friday Belfast Agreement. So there are 6 formal areas of cooperation, including agriculture, the environment, health, transport, tourism, the implementation bodies, for example, trade and food safety, and then another, a vast range of other areas of cooperation, such as justice, higher education, broadcasting, energy, arts and culture. So this mapping exercise, which interestingly enough came up with almost the same number of policy areas, areas of cooperation as we'd seen in the common frameworks, around 142 or so. This was conducted and led then to some much needed recognition, I think, of the value or the importance of the EU context for North-South cooperation, and as a knock-on effect of that, the importance of it for the Good Friday Belfast Agreement. And so we had the joint report that was issued, a really considerably significant document issued in December 2017, in which the UK expressly underlined its commitment to protect North-South cooperation and recognise that any future arrangement between the UK and the EU had to be compatible with the overarching requirements of maintaining North-South cooperation. Of the 142 areas that were classified as directly linked to EU law and membership, that could be, for example, through funding, not necessarily in other ways. 54 were seen as directly linked, 42 is partially linked, and then 46 is not linked at all. And some of those 46 are very, very small things, just affecting a school, for example. Anyway, the key point is that this fed into the backstop, which the backstop would have avoided Northern Ireland being stretched between GB and the EU because of what it required of the UK, hence the resistance to the backstop from pro-Brexit MPs. And then, of course, the principle of North-South cooperation remained very present in the protocol that was concluded in October 2019, minus the reference to the all-island economy. So as Colm has helpfully identified, Article 11 of the protocol talks about maintaining the conditions for North-South cooperation. It lists those areas of cooperation that we have listed in the Good Friday Agreement, and it mentions the implementation bodies, of course, as well as a range of other areas. Again, they're mentioned in the Good Friday Agreement, but they're not spelled out. We don't have anything, as Colm has already said, we don't have any more detail on this, any sense of the scope or limitations of that North-South cooperation and how the Joint Committee is seen as overseeing and maintaining those conditions, what that actually looks like in practice. It allows for bilateral cooperation between the UK and Ireland to build on those areas of cooperation, to build on the provisions of the Good Friday Agreement in North-South cooperation. And as has been mentioned, that sense of this now becoming an UK-EU area of responsibility, in that the Joint Committee must keep under constant review the extent to which the implementation application of the protocol maintains the necessary conditions for North-South cooperation. Now, as an aside, the mention of water quality in the environment is a really important one, because that's being brought up by many people in Northern Ireland with regards to common frameworks. That isn't a common framework at the moment that's seen as requiring legislation. In Northern Ireland, people are anxious to have that legislation, that common framework, recognising the potential for divergence in that area. What do we also have in the protocol in terms of responsibility being given to the Joint Committee isn't just about North-South cooperation. The Joint Committee is also given responsibility for keeping under constant review the protection of the UK internal market, Article 6 of the protocol. So we have an extraordinary situation in which the Joint Committee, the UK-EU Joint Committee, is charged with keeping both the UK's internal market and North-South cooperation on the island of Ireland under constant review. And this raises as many questions as it answers, really. It's worth noting that there's no decision-making power for the Northern Ireland Executive at the Joint Committee. In fact, the Northern Ireland Executive doesn't automatically have a seat at the Joint Committee. It has to be invited by both the UK and the EU. Sorry, by the UK. Sorry, and the UK will do that if Ireland is present at the Joint Committee. Just to conclude, these are dynamic areas of change. I've mentioned that the Northern Ireland Protocol means that dynamic alignment for Northern Ireland with EU law in many respects. And of course, we expect dynamic change within the UK too as a consequence of Brexit. The environment within which Northern Ireland is managing a rather precarious place in the United Kingdom and in the EU's single market extraordinary position is radically transformed, with a huge amount of uncertainty about how this might actually be negotiated and maintained, scrutinised, and made transparent in the coming years. The reality is that for Northern Ireland, the links and relationships and ties both to GB and to Ireland will become increasingly difficult at the same time as they're becoming increasingly important in economic terms as well as political terms. And this isn't just a challenge for Northern Ireland, which is very weakly positioned to deal with it. And I'm not going to talk about our executive and the state of it at the moment. It's an ongoing challenge for the EU and for the UK. And this is very much, of course, a legal as well as a political and a technical challenge. Thank you.
Many, many thanks. That talk is full of knowledge of an immense amount of very challenging details, which I'm afraid our political leaders would rather not learn too much about. Now, we have the next problem of Northern Ireland, and we're going to hear from Brice Dickson. Welcome. Thank you for coming.
Thank you very much, Ian. Good morning, everybody, and thanks to the Franco-British Lawyer Society for organising this event and for inviting me to participate. I'm going to focus on a very specific issue, really, which is what effect does Brexit have on discrimination law in general in Northern Ireland and on employment law within Northern Ireland. And I'm going to divide my presentation basically into 4 parts. So I'll begin by contemplating what the EU has done for Northern Ireland as regards discrimination and employment law to date. I'll then look at the effects of the withdrawal agreement in this area for Great Britain, or for the UK really as a whole. But then thirdly, the effect of the withdrawal agreement in these areas for Northern Ireland. And then finally, I look at the potential that the lawmakers have in Northern Ireland for continuing to protect people against discrimination and to enhance their employment rights. So starting off with what has the EU ever done for us in this area? Well, the reality is it's difficult to overestimate, I think, the contribution which EU law has made in the fields of discrimination law and employment law since 1973. As we all know, the treaties, regulations, directives, decisions of the European Court of Justice have made a fantastic contribution in those fields. And the UK hasn't always covered itself in glory in terms of complying with those legal requirements. I'll remind you that back in 1982, the UK was held to have breached the Equal Pay Directive of 1975 because it wasn't ensuring equal pay for work of equal value. And in 1994, it was found to be in breach of the directive on collective dismissals because employers were only required to consult with workers on dismissals, on redundancies, if they recognised a trade union in their workforce. And at that time, recognition of trade unions was a voluntary action on the part of employers. It wasn't compulsory. In 2007, the UK was again held to have breached on this occasion, the Working Time Directive of 1993, because UK law didn't ensure that workers could benefit from their right to effective rest under the directive. There have been 1 or 2 occasions when the UK has succeeded in infringement brought against it. For example, in relation to the Health and Safety at Work directive, the UK won its argument that it was enough to comply with that directive if UK law simply required employers to take whatever steps were reasonably practicable to protect safety and health. And as well as those directives on employment law, there have, of course, been very important directives on discrimination. The principles directives at the moment applying in this field are the 2000 directive on equal treatment between persons irrespective of their racial or ethnic origin, the 2000 framework directive on equal treatment in employment and occupation, covering in particular possible discrimination on disability grounds, on sexual orientation grounds, on religion or belief grounds, and on age grounds. Then we have the 2004 directive on the principle of equal treatment between men and women in access to and supply of goods and services, and the 2006 directive on the implementation of the principle of equal opportunities and equal treatment of men and women in matters of employment and occupation. Now, the UK has implemented those directives, including in Northern Ireland, but it's worth bearing in mind that the UK and Northern Ireland have for long had their own set of laws dealing with discrimination, particularly in the employment area. It's worth bearing in mind that the first Race Relations Act in the UK was passed as long ago as 1968. That equal pay legislation was introduced in 1970, both in GB and in Northern Ireland. That an act called the Fair Employment Northern Ireland Act was passed in 1976 to deal with religious and political opinion discrimination in Northern Ireland. And that in 1995, and we've just celebrated the 25th anniversary of it, the Disability Discrimination Act was passed for the whole of the UK, an act which had no derivation from EU law as such. So for long we have lived in the UK and in Northern Ireland with EU law on discrimination and employment being superimposed on and intertwining with domestic provisions. And Northern Ireland has always been a bit different from the rest of the UK in the field of discrimination. We didn't, for example, have any law protecting us against race discrimination until 1997. The Equality Act 2010 that was passed by the Westminster Parliament, and which consolidates a lot of the discrimination law and implements the 2000 Framework Directive, it doesn't have an exact equivalent in Northern Ireland. We do here have particular protection against political opinion discrimination, which doesn't exist elsewhere in the UK or in many places within the EU. So while we're not as well off in some areas, we're better off in one or two other areas. GB has protection, for example, against age discrimination on the basis, in the context of access to goods, facilities and services. The EU doesn't yet have a directive on that field, and Northern Ireland doesn't yet have laws protecting people in that area either. So there is asymmetry, not just between the UK and EU, but between Northern Ireland and Great Britain. Turning then to the effects of the withdrawal agreement on the UK in general, before looking at the Northern Irish position, it's clear that quite early on in the negotiations following the referendum, or in the government thinking following the referendum result, the decision was made to try not to disentangle all the EU law from domestic law, but rather to go with the idea that on the day that EU exit finally happened for good, the law that currently derived from the EU, or that was required to be implemented because of EU law, would be retained. The concept of retained EU law, which is affirmed by sections 2, 3 and 4 of the European Union Withdrawal Act of 2018. And for the avoidance of doubt, the 2018 Act makes it explicit that the principle of the supremacy of EU law will not apply to any enactment or rule of law passed or made after exit day, but that EU supremacy will still apply to retained EU law unless and until it is replaced by domestic law. So that means that if a conflict arises between pre-exit domestic legislation on employment or in the field of discrimination, the supremacy of EU law principle will continue to apply as it did before exit day. And the principle of supremacy of EU law also means that domestic law made before exit day must be interpreted as far as possible in accordance with EU law. And I know that Lord Justice McCloskey will be talking about the Charter of Fundamental Rights, but under Article or Section 5.5 of the EU Withdrawal Act of 2018, while the Charter of Fundamental Rights will not be forming part of our domestic law after exit day, the underlying fundamental rights and principles on which the Charter is based will still be part of retained EU law and will continue to have an effect in the way that other retained EU law will have. It's worth pointing out at this point that the Withdrawal Act provides protection for workers' rights insofar as EU citizens who are already working in the UK can apply under the EU settlement scheme for a certificate entitling them to remain and work in the UK. And after 5 years of residence, they can apply as they can already for a permanent residence permit. UK nationals wanting to go to work in the EU, well, first of all, those already working in the EU will retain their right to work there, but those who want to apply to go to work there will have to produce a certificate setting out whatever their criminal record might be in the UK and their right to work with children. They might, if they want to work with children, they have to have a certificate to that effect, and they will have to satisfy the domestic requirements of the EU country in question. So I think in the case of France, they will have to acquire a casier judiciaire, a criminal record certificate, giving an indication of what, if any, criminal record they have in France. Turning then to the more particular effects of the withdrawal agreement within Northern Ireland, the protocol on Ireland and Northern Ireland, which is mainly intended to deal with the fact that Northern Ireland will remain in the EU's customs union and single market, as well as within the UK's internal market. It also has consequences for discrimination law and anti-employment law. The fact that a lot of people who live in Northern Ireland claim to be Irish nationals rather than anything else, which they're perfectly entitled to do, especially if they've been born on the island of Ireland. The fact that there are perhaps 30% of the population who have that identity back in the 2011 census, somewhat remarkably, I think, only 26% of the people in Northern Ireland claim to be only Irish nationals and not, say, Irish and British nationals. But that figure has probably increased since 2011. Let's say it's 30 or 35% in the 2021 census. Well, the protocol makes it clear that people who consider themselves to be Irish nationals will, after exit day, they mustn't find themselves in a position that is different from their counterparts in the Republic of Ireland. One of the introductory paragraphs to the protocol recognises that Irish citizens in Northern Ireland will continue to enjoy rights by virtue of their EU citizenship, and that the protocol must respect the rights of the people of Northern Ireland who to choose their right. The protocol should respect the rights of the people of Northern Ireland who choose to assert their right to Irish citizenship to continue to be able to do so. And I should point out to those who are not familiar with the terms of the Good Friday Agreement, perhaps, and of the British-Irish Agreement, which accompanies the Good Friday Agreement, all persons born in Northern Ireland who have at the time of their birth at least one parent who is a British citizen, an Irish citizen, or otherwise entitled to reside in Northern Ireland without any restriction on their period of residence, all those people have what's called the birthright to consider themselves to be British, Irish, or both. And the protocol preserves that right. The withdrawal agreement also contains provisions protecting the rights of frontier workers, who are people that live in one state but who work in another. And it's pretty clear from Article 12 and Articles 23 to 25 of the withdrawal agreement that such workers are protected against discrimination in general, and in particular in relation to particular employment rights, and also social and tax benefits that they're entitled to, housing rights that they might otherwise be entitled to, and even the education rights of their children must continue to be protected after exit day. Article 2 of the protocol also promises that the UK must ensure that the withdrawal from the EU will not lead to any diminution of the rights conferred by the Belfast Agreement, including the rights not to be discriminated against as enshrined in EU law. And the protocol has an annex which lists not just the 4 directives that I mentioned earlier in this talk, dealing with discrimination in the field of employment and more broadly in some respects, but it also adds 2 other directives, the 1978 directive on equal treatment of men and women in matters of social security, and the 2010 directive on equal treatment of men and women in self-employment. So in effect, the inclusion of those directives in the annex to the protocol means that they must continue to be applied in Northern Ireland and complied with in Northern Ireland, even if in the rest of the UK the law is changed so as to diminish those rights, or so as to create any kind of difference between GB law in the fields of discrimination and employment and EU law. And it's worth emphasising that Articles 13, 2 and 3 of the protocol mean that if the directives I've just mentioned are interpreted by the Court of Justice in a certain way going forward, or if they are amended or replaced in some kind of way by EU law, then those amendments, those interpretations must continue to be applied in Northern Ireland in the same way as they would be in the rest of the EU. There are a couple of safeguards written into the protocol as well. There's to be a joint consultative working group on the implementation of the protocol, which is intended to ensure that the protocol is properly implemented. And there's a further important safeguard in that 3 separate institutions, that's the Northern Ireland Human Rights Commission, the Equality Commission for Northern Ireland, and the joint committee that's been set up between the Northern Ireland Human Rights Commission and the Irish Human Rights and Equality Commission. All those 3 institutions can bring any matter which is relevant to Article 2 to the attention of the specialised committee that's been set up under the withdrawal agreement. And that's an important safeguard, I think. And there is the arbitration panel, which Judge McCloskey mentioned earlier, which has been set up and will comprise a total of 25 members, 10 of whom will be chosen by the UK, 10 by the EU, and 5 jointly by the UK and the EU. So that's a further degree of protection for the rights referred to in the protocol. Turning to the last part of my talk then, which is the potential role of the lawmakers in Northern Ireland to protect people against discrimination and to protect their employment rights going forward. Well, the withdrawal agreement has largely been incorporated into our domestic law by the European Union Withdrawal Agreement Act of 2020. And Section 14 of that Act allows, quote, an appropriate authority to make regulations on, for example, non-discrimination, equal treatment and workers' rights, etc. And the term appropriate authority includes devolved authorities. And for Northern Ireland, that means the Northern Ireland Assembly, a Northern Ireland Minister, or a Northern Ireland Department. Going forward, therefore, those lawmakers in Northern Ireland will retain the power they have currently, because equality law and employment law are devolved matters in Northern Ireland. They will retain the ability to make laws in those areas and might indeed acquire further competences to do so, given that the EU competences in the field are being returned to the UK, and some of those will in turn be devolved to the regions of the UK. So Northern Ireland differs slightly from Wales and Scotland in that it has for long had further devolved responsibility in the fields of equality and discrimination. And that will continue to be the case going forward. So after exit day on the 31st of December 2020, it will be open to the lawmakers of Northern Ireland to pass legislation that protects people against discrimination and protects other workers more extensively than is currently the case, or than that will be the case in Great Britain if they pass laws that differ from those in the EU. The lawmakers must simply ensure that they don't diminish the rights protected in the directives and don't diminish the rights in the Good Friday Agreement. So summing up my position or my presentation, I think that we can be reasonably certain that following Brexit, there will not be any immediate diminution in the protection afforded by the law of Northern Ireland to victims of discrimination and workers. And even if Westminster Parliament seeks to pass laws in those fields for Northern Ireland, which it can strictly do under its sovereignty position, though contrary to the Sewell Convention, which they're meant to comply with, but that's really just a political restriction on their powers. Even if the UK did attempt to do that, it would be a breach of the agreement, the withdrawal agreement, and could be dealt with by the sanctioning processes that are within the withdrawal agreement. We've already seen infringement proceedings begun against the UK as regards the internal market bill, and that might be some kind of precedent going forward if the UK government, or indeed the Northern Ireland government, fails to comply with the protocol. I'm an optimistic person, though, by nature, and I like to end presentations on a positive note. So I'm hoping that going forward, discrimination and employment laws will be adequately protected here. Thank you, Ian.
Thank you. Thank you very much. And now, just looking at the clock, yes, we're still moving forward. Katy may need to leave us shortly, but we're still approximately there. So our next speaker is Lord Justice McCloskey. Many, many thanks for your interest in the Society over the years, and thanks for being here this morning.
Good morning. Thank you very much indeed, Ian, for those introductory remarks. I'm coming over clearly, am I?
You are.
Great. Good morning to you and my fellow panelists, and to all taking part. It's my great pleasure and an honour to contribute to this landmark event and to form part of a distinguished group of speakers and participants. I was given more or less carte blanche on what to say, and that reminds me that I should also be saying bonjour surtout to mes amis et collègues de la Société Franco-Britannique. Having taken full advantage of the blank sheet that was presented to me, I've been prompted to identify a canvas of what might be described as somewhat broader rather than parochial scope. And indeed, I have found in my reflections on my forthcoming presentation that all, or virtually all, of what I wish to say applies fully to the United Kingdom, and in no special or particular way to Northern Ireland. And that, of course, is a consequence of constitutional realities. The approach which I have been minded to adopt has been prompted in particular by my close association in recent years with two organisations. First of all, the European University Institute of Florence, and my involvement in a project there which is coming to fruition. And secondly, the Association of European Administrative Judges. Now, I have taken both as my starting point, and indeed the main focus of what I wish to say, the Charter of Fundamental Rights, or the so-called Lisbon Charter. I did so because of one of the standout features of the domestic UK EU withdrawal legislation from day one of what has become a prolonged withdrawal process and period. From day one, the Charter got the boot unceremoniously and almost triumphantly in the very first version of the primary legislation devised to give effect to the Brexit referendum. That caught my eye for a variety of reasons and has driven me to reflect on a number of features of the Charter, particularly, of course, in the context of UK law. The fundamental difference between pre-Charter and post-Charter times is that the rights of EU citizens were, via the Charter, proclaimed and codified visibly and unambiguously in a model which itself is transparent, unequivocal, and dynamic. The rights enjoyed by Union citizens became more concrete, tangible, and accessible than ever before. With the advent of the Charter, a new era in the EU legal order dawned. The Charter represented both the vindication and the codification of the jurisprudence of the Court of Justice, which developed the cornerstone principles of equal treatment, non-discrimination, transparency, legitimate expectations, and the legal recognition and protection of other fundamental rights and freedoms. The Charter must be viewed in the context of Article 6.3 of the TEU, which provides that fundamental rights shall constitute general principles of EU law. And the Charter, of course, sits proudly at the apex of EU constitutional law. If one examines the roots and the background of the Charter, one comes to the conclusion quickly that during a period of many years, there was active, imaginative, and penetrating judicial interpretation and application of EU law, which included the discovery and proclamation of fundamental rights. Thus, the Charter may properly be said to be the vindication of the tireless work of dedicated supranational judges. The manifest diversity, breadth, and versatility of the Charter are amongst its hallmarks. These traits can be readily traced to the UN Declaration of Human Rights, the Statute of the Council of Europe, the Treaty of Rome, and to a lesser extent, the Refugee Convention, all of which were adopted within a period of flurried activity in the wake of the Great War, the Second World War, and also, of course, in tandem with the progressive jurisprudence of the Court of Justice and the increasingly influential case law of the European Court of Human Rights. I will reflect briefly on how that is going to operate in a post-Brexit world. The creation of the EEC as it was, it did not occur, of course, in isolation. One must recognise the more or less simultaneous adoption of the Statute of the Council of Europe, which in common with its EEC counterpart had as one of its aims the achievement of greater unity among European states in the midst of the devastation caused by the Second World War. The statute, reacting to the appalling loss of life, the refugee crisis of unparalleled dimensions, and all of the other humanitarian devastation of the war, devised an elaborate human rights protection model, namely the Convention on Human Rights as its marquee mechanism. The resulting interaction and approximation of the two regimes, that is the European Union and the Council of Europe, was in hindsight predictable, if not entirely seamless. With the passage of time, each would inevitably be influenced by the other and absorb the other to an appropriate extent. These reflections drive home the message that the creation of the European Union, the establishment of the Council of Europe, were both fundamentally international peace measures. This is one of the messages which became depressingly lost from the beginning to the end of the Brexit campaign. Viewed retrospectively, it was inevitable that the EU institutions, in particular the Court of Justice, would be alert not merely to the activities which were taking place under the umbrella of the Convention on Human Rights, but also, of course, the jurisprudence of the European Court of Human Rights, which, let us say, had a rather slow start, but then began to accelerate notably in its second and third decades. So that brings me to examine briefly the status and influence of the Charter in the United Kingdom before Brexit. The UK, though uniquely among EU member states having no written constitution, is a single constitutional entity. For the benefit of our international participants, it consists of England, Scotland, Northern Ireland and Wales. However, for reasons of history, tradition and evolution, the three countries, that is England and Wales together, Scotland and Northern Ireland, operates a legal system having its own distinctive traits and procedures and scope. The exercise of considering the operation and influence of the Charter in these three countries is not a difficult one. Furthermore, it is instructive to consider how the Charter has fared in our sister country, the Republic of Ireland. It is no understatement to suggest that the Charter has had an impact that has been at most tepid in England and Wales, in contrast, I suggest, with how it has fared in the Republic of Ireland. And there are some interesting explanations or possible rationalizations of why that should be. Nonetheless, it is an inescapable fact that on Brexit Day, the operation of the Charter in the UK had not been adequately analysed or researched, albeit in 2017 it was found to be operating satisfactorily. And secondly, of course, it had not begun to achieve its full potential. The question of post-Brexit human rights protection therefore arises. There has been increasing controversy, acrimony, and uncertainty, at times bordering on confusion, in the process that has popularly become known as Brexit. Paradoxically, the Charter is one of the reasons why Brexit occurred. The Charter was portrayed as one of the evils of membership of the European Union. This is a sad reflection of political reality and a worrying paradox. While the June 2016 referendum leave vote represented a seminal event in the shared history of the UK and the EU, it has been regarded in the eyes of many citizens and sectors, international audiences and organisations and so forth, as a retrograde, insular and myopic step. Withdrawal Day became a legal reality on the 31st of January 2020, the date of execution of the mutually binding, or what we thought was the mutually binding, international agreement. And I'll say a very quick word about that in just a moment. Finality, of course, has not yet been achieved, and the hard bargaining continues. The effect of Brexit is that England and Wales, Scotland and Northern Ireland will all find themselves outside the EU legal and constitutional order, subject to certain exceptions and qualifications. The focus has been very much on Northern Ireland because uniquely it is the only part of the United Kingdom which shares a land border with an EU member state, and uniquely has its population citizens who, if they wish to do so, can obtain the nationality of another EU member state, namely the nationality of the Republic of Ireland, and many indeed possess this already, and if they do so, will continue to have the status of EU citizens. But that has to be worked out. That is one of the many conundrums which have not been nearly adequately addressed throughout. The Withdrawal Act repeals the European Communities Act 1972. It preserves laws made in the UK for the purpose of implementing EU obligations, and it converts EU law into domestic law, subject to specified exceptions. And this Charter, as I've said, is one of the most striking of these exceptions. It ceased to form part of domestic UK law on and after the exit day. It is the fact that, for example, as demonstrated by the UK-Poland protocol, from its inception, the Charter was treated with suspicion by successive UK governments, and it applies, or did apply, of course, only where member states were acting within the scope of EU law. But the institutions of the United Kingdom will no longer be acting within the scope of EU law post-finality. However, ambiguity and inconsistency, to which some reference has already been made in the Withdrawal Act, are immediately identifiable. I should say that if there's going to be a field day for lawyers and judges regarding the protocol, we'll be arguing about the meaning and scope of the Withdrawal Act for decades. The Charter codifies certain existing rights which, under the Withdrawal Act, will be retained in UK domestic law by Section 5, subsection 5 of the Act. Furthermore, any fundamental rights or principles under EU law which exist irrespective of the Charter will be retained in domestic law. There will also be the mechanisms of retained EU law and retained EU case law, albeit neither has any guaranteed long-term existence in the United Kingdom. The Charter will remain influential in all aspects of retained EU law and retained EU case law, which it affects. That applies to cases that have been decided already and cases which will be decided in the future by the CJEU. There will also be scope for the Charter to influence the development of the common law by judges, particularly on account of its links with the Convention on Human Rights. Contrary to public misapprehension, the Convention on Human Rights remains unchanged by Brexit and will remain part of UK domestic law in its partial implementation via the Human Rights Act 1998. However, turning to reality, given the doctrine of the supremacy of Parliament, which will be reinvigorated by the recovery of partial loss of sovereignty which Brexit brings about, democratically made legislation will be capable of eliminating or diluting any measure of retained EU law at any time. And we know that there is a very heavy, complex process underway at this point in time. Parliament will be accountable, of course, to the UK electorate, but the fact of a large government majority, buoyed by the Brexit referendum vote and subsequent so-called victories of a political nature in the interaction with EU institutions, inevitably looms large. That brings me then to reflect briefly on the following as I approach, I hope, a conclusion. The Charter is identifiable in various measures of EU law and various decisions of the CJEU, to the extent that it is arguably contrary to the legislation purporting to abolish it, namely the Withdrawal Act. The Charter will continue to have some enduring influence in three particular ways. First, the rights protected by the Charter are more extensive than those enshrined in the Convention on Human Rights. Second, however, the abolition of the Charter will give rise to a significant draft in the matter of available judicial remedies. And the third ineluctable consequence of the Brexit arrangements is that the disappearance of the Charter is likely to have a negative impact on the culture of human rights protection in the UK. This particular negative consequence is potentially the most significant of all, and drives one to reflect on at least four reasons for being concerned about the present and future rule of law culture in the United Kingdom. These are the following. One, the Brexit decision of the UK Supreme Court, published in September 2019, provoked a vitriolic outcry against the judiciary of unparalleled proportions, in which some senior government members were prominent. Two, the government quickly announced that there would be a fundamental review of judicial review, which is currently underway. Three, the government has recently announced a review of the Human Rights Act. And fourth, the UK Internal Market Bill, published on the 9th of September, contains a provision which succinctly declares a government policy of preparedness to breach an international treaty, namely the UK-EU withdrawal agreement, in other words, to violate international law. Now, it is worth looking at this in a little detail because the intricacies are many. I'll try to summarize this in a couple of sentences. The Internal Market Bill is predominantly concerned with regulating the free movement of goods and services and the recognition of professional qualifications in the post-Brexit UK world. The UK government has included in this measure a provision which contemplates that the UK will fail to honour Article 4 of the Withdrawal Agreement. The purpose and effect of Article 4 were to ensure that the provisions of the Withdrawal Agreement, including the Northern Ireland Protocol, could be enforced directly in the UK courts if necessary, and to empower UK courts to disapply inconsistent and incompatible provisions of domestic law. The UK undertook to enact primary legislation to confer this jurisdiction on the courts. The UK then sought to implement the withdrawal agreement through the 2020 Act. The government's declaration of intent in the Internal Market Bill is found in clauses 40 to 45. In the briefest of summaries, these provisions create conflict between the UK's proposed new internal market and the operation of the Northern Ireland Protocol in two particular respects. These are firstly the movement of goods between Northern Ireland and Great Britain and the application of EU state aid rules. To summarise, the UK government has declared that it will refuse to honour the withdrawal agreement if it finds it convenient to do so. Furthermore, the bill purports to exclude the possibility of judicial review in certain matters. The trend which these various developments that I am describing reflects is a worrying one. The culture and philosophy which they exemplify are illustrated in yet another recent development, and we've all read and heard and been appalled by the lefty lawyers and the activist lawyers' statements of senior government principals, described it really by the Prime Minister himself as, and I'm quoting the exact words, lefty human rights lawyers. What about EU citizens living and working in the UK post-Brexit? Well, in short, the abolition of the Charter will weaken the legal protections available to them. Pre-referendum, the prevailing environment and culture in the UK already had a hostile disposition towards non-British nationals, and there are multiple examples, but in particular unaccompanied children and destitute foreigners on our lands. What I will try to do, therefore, is to draw together some concluding remarks, having regard to the limited time available and my failure to observe the time limit, for which I apologise. So I'm posing the question to sum up: will the exile of the Charter of Fundamental Rights after exit day be final and absolute? The answer which I proffer is a negative one, but it inevitably has certain qualifications. The answer is based on the following provisions of domestic UK legislation, that is, the withdrawal legislation. First of all, while the principle of the supremacy of EU law will not apply to any enactment or rule of law made on or after exit day, the supremacy principle will nonetheless continue to apply so far as relevant to the interpretation, disapplication, or quashing of any enactment or rule of law passed or made before exit day. There will undoubtedly be an argument of some plausibility that in giving effect to this statutory provision, Charter cannot be disregarded. Secondly, any fundamental rights or principles of EU law which exist irrespective of the Charter will be retained in domestic law, and by itself gives rise to the possibility of resort to the Charter's mechanisms, for example, its explanations, or to its jurisprudence, provided that an identifiable nexus can be established, and imaginative lawyers won't have much difficulty in doing that. Third, the Charter could conceivably make a formal or official reappearance in the event of the exercise of the statutory ministerial power to act so as to prevent, remedy, or mitigate any failure of retained EU law to operate effectively or any other deficiency. If it were to do so, of course, this would be achieved, no doubt, for political reasons by stealth and not overtly. Fourth, the Charter will continue to operate, albeit on a short-term basis, insofar as relevant to any proceedings begun, but not finally determined before a UK court or tribunal prior to exit day. If courts and tribunals are given the discretion to have regard to the magic words, judgments of the CJEU post-stating exit day, which may of course include charter-related decisions. 7, domestic courts are also given the discretion to have regard to what is done by another entity of the EU, insofar as relevance to any case of which they are seized. This would embrace, intriguingly, for example, reports and publications of the EU Fundamental Rights Agency. 8, I've only got 11 of these, my apologies. 8, charter rights which can be identified and recognised as expressing a fundamental right or principle existing irrespective of the charter will form part of retained EU law. 9, courts and tribunals are specifically empowered to have regard to and give effect to post-exit day CJEU judgments which do not depart from pre-exit day CJEU judgments. And that's a very obvious gateway, if I may say so. 10, a court will be able to disapply legislation or quasi-relevant act where a challenge relates to something predating exit day and is made within a 3-year limitation period. Again, potential for the charter to flicker at least. And 11th and finally, any court decisions pre-exit day, quashing an act or decision, or disapplying a provision of pre-exit day secondary legislation on the ground of incompatibility with one of the general principles of EU law will continue to have effect. I recognise at once that all of this is not less than complex. I tried to put it all together in those few propositions, and I make the following conclusion. I apprehend that the extent of the Charter's post-Brexit influence in the UK, that is the ability of the Charter to contribute to the promotion and safeguarding of the rule of law and the protection of fundamental human rights, will depend significantly on 2 factors in particular. The first is the innovation and creativity of UK lawyers and judges. And we saw much of that during the twilight periods, which occupied accession to the Convention on Human Rights, the Council of Europe, by the UK all those decades ago, and the final adoption of the Human Rights Act 1998. The second is the future rule of law culture in the United Kingdom. Effective human rights protection, particularly in a country which has no constitution, will be heavily dependent on a strong rule of law culture. What the future holds for this culture in the UK is something of an incognito and a matter of legitimate concern. Thank you all for your patience and attention.
Wow. Thank you very much. Thank you very much. These are difficult and sensitive matters. We have a couple of questions, not many, and time is passing. Let me just mention the questions. One is, it's not really a question, it's an intriguing observation, and I'm reading. It's a quote from Michael Collins in 1922, who said the then treaty was, in his words, the freedom to achieve freedom. That is, to sign and then to break the text that you've signed. And the commentator suggests that Mr. Johnson, 98 years later, seems to be pursuing this approach to treaty drafting. That's easy to say. And then how do we see this playing out? Well, I don't think. I think it needs someone with a better crystal ball than us to make a view. And then from our founder member, Simon Horsington, he notes that the UK seems likely to pass an agricultural law which prohibits the export of live animals for reasons of animal welfare, because the export of live animals as opposed to meat exposes the creatures to greater danger of disrespect for their interests in continental Europe. And his question is, how will that, assuming it were to pass, impact the island of Ireland, north and south? Now, who wants to talk about that? Live animals.
Ian, I think that would have been a question for Katy, probably, had she still been with us. The reality is at the moment that there is, in effect, a single regime throughout the island of Ireland as regards sanitary and phytosanitary plant health issues. So I'm not quite sure that the agricultural bill or act would change the fact that there is this unified system within the island of Ireland, but I could. Bernard might know better.
All right.
Could I just say a word about that as well?
Colm.
I don't understand the Ireland and Northern Ireland Protocol to prohibit either the jurisdiction of Northern Ireland or the jurisdiction of the Republic of Ireland from adopting a different or a higher standard to the standards which apply in the EU. So if the Stormont government or the UK government wish to impose a rule in Northern Ireland prohibiting the export of live animals from Northern Ireland to the Republic, the protocol would not prevent that from happening. I don't see any difficulty with it.
All right. Time is moving, and lots of our watchers have busy schedules. I'd love to keep talking for another hour, but I think I very much want to hear from David Edward, whose summations have been one of the attractive features of these webinars, because typically, as now, we get a mass of information and there's a pause for reflection, and David valuably contributes to making that reflection more digestible. That's a mixed metaphor for which I apologize. So David Edward.
Thank you, Ian, and thank you to everybody, including Fionnuala Connolly, who was a stagiaire in my cabinet long, long ago. I hate, from her point of view, to say how long ago. I think the underlying message of all of this is about peace. Most of us have been fortunate enough not to be affected by the violence that anybody in Northern Ireland or the Republic will have been aware of, and in some cases suffered from. I did visit Northern Ireland during the height of the Troubles, and I was aware of the effect of that on everybody's life. And then that leads me back to the origins of the EEC, because when I started on this voyage, so to speak, I was a member of the Scottish Bars delegation to the CCBE, the Council of Bars and Law Societies of the EU. And at that time, some of the members had suffered severely during the war. A number of them had been in concentration camps. One had lost a leg at Stalingrad. Another had been the commandant of one of the last Hitler Youth battalions, and woke every night with a nightmare of his troops, his boys, crying for their mothers. The effect, and these were only small illustrations of the effect of the war on human beings, and likewise the Troubles have had a similar effect on people in Ireland. And I think as Scots, we have to be aware of that, and aware of that as a consequence of separation. Therefore, I think that one has to see that as the encompassing message of anything about Brexit. More particularly, I think that what we have had explained to us are the components of peace in Northern Ireland and in the Republic of, and in the island of Ireland. The components being a working, democratic, transparent, and impartial legal system. And that is the importance of that, or is illustrated by the comments on the rather frivolous attitude of the United Kingdom government to legal obligations. It seems to me that, as somebody said, this will be work for lawyers for many years. And again, Lord Justice McCloskey illustrated the problem of lawyers in the present political context. We are unpopular with government, and we have to maintain our position, I think, as in relation to our obligations as lawyers. So in the context of the legal problems raised by Brexit, I think it does illustrate two things, or one thing in two different aspects. And that is that the United Kingdom as a state is a state of variable geometry. It is not a single solid organized, conventionally organized state. England, Scotland, Ireland, and Wales all form part of the common law heritage, and yet they work differently in their own way. And that is part of the nature of the United Kingdom and the relationship of the jurisdictions on these two islands. But more particularly, we have to consider now the variable geometry created by the interaction of EU law with domestic law. And one last thought, because I've said too much, I think, perhaps. I think it was Judge McCloskey said that the EU had given Ireland a separate voice. And I think that his emphasis on the way in which the EU has given a place to small nations, a voice to small nations, is a lesson that has to be considered. And I'm thinking most particularly of the voice of the Baltic countries, the three Baltic countries, who did form part of the Soviet Union. And the way in which the EU as an organization has given a voice to small countries who have suffered from the misbehavior of big countries is one of the great things to the credit of the EU. Over to you, Ian.
Indeed, just echoing that last remark. Every year, the Court of Justice invites the senior magistrates, the Supreme Courts of the 28, 27 countries to come to Luxembourg for a knees up and to discuss matters of mutual interest. And of course, there's a bit of difficulty sometimes in finding safe things to talk about. And quite often the events are a little bit sonorous, a little bit safe. We talk about anonymity of judgments or access to the profession. They're important, but they're not dangerous. And I vividly remember year before last, the then Chief Justice of Lithuania getting up and speaking about what it was to live in a world where rights were endorsed in the books, but abused by soldiers and police in the streets. And I was sitting in the huge hall in the Court of Justice, dozing a little bit, I must confess, before he started to speak. And the palpable impact of the importance of peace and decency was vividly recollected. And I'm glad that we have ended this interesting discussion by being reminded of that by David Edward. I thank all of you for participating, those whom I can't see who are looking at me, and those whom I can see who've been the speakers, plus Mia, Sophia, and of course Fianula. I'm very, very grateful to you. Now, I know we're all getting too many webinars these days, but I tell you, next Wednesday, 1 week from today, we will have a topic selected months ago, Brexit, where are we now? And of course, I assumed, stupid me, that we would know where we were on the 25th of November. We have Dominic Grieve, formerly Attorney General of the United Kingdom, and formerly a member of the Conservative Party. We have Michael Russell, the Minister in the Scottish Government responsible for Brexit. We have Chris Gray, the author of the Brexit blog, not comfortable reading, but very, very well informed. And we will have the yet to be identified, it depends on technology, spokesman on behalf of British in Europe, talking about where we stand with the various litigations that are presenting questions of the ongoing or not rights of Brits in 27 and vice versa in the UK. So I apologize for running over by 10 minutes. I very much am grateful for the help to set this up. And I hope that as many of you as are free will mark your diaries, notwithstanding the other interesting things that everyone can do in the course of a day as sunny as this one. And maybe we'll see you next week at the webinar on Brexit, where do we stand? Thank you very much, ladies and gentlemen. And I'm going to close this meeting. Thank you all from Northern Ireland in particular. Bye-bye.